Well, let us get back to the discipline, the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my Lord put between. I think my Lord the Chief Justice put it. Was Nabam Rebia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethmalani tried to address the issue directly today morning. And perhaps he has not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your lordships. Just note in sequence, the lord should be astonished how much entirely relies on the Nabam Rebia, which is why your lordship will refer it, unless your lordship wholesale agrees with Nabam Rebia, obviously. If your lordship doesn't agree with Nabam Rebia, it has to be referred. Now, there is one important point here. I did not say it until I showed the page. Along with this reliance on Rebia, which I will develop in a minute, is a major suppression. And both suppressio veri and seditio falsi, both aspects also. Your lordship heard hardly 1 hour ago that nothing turns on this because this was rejected. Your lordship heard it just now. Where is the rejection mentioned here? You have come to a court in a vacation seeking urgent interim relief involving the possible toppling of a government. Today, because it suits you, you argue that it was rejected. Now the whole para is here. Lordship will look behind and forward. There is no mention of rejection. It's completely suppressed. Now go on. And it's true in constitutional adjudication, we can have very large, nice issues, but ultimately there should be some discipline of law. How you came to the court, what you relied on, today your lordship is considering reference, not the merits. No, see the whole construct, the basis on which you came, you entered the door with this basis, got an order, and today because Nabam doesn't suit you, you have been disloyal to Nabam and bemoaning it. The title is, when a resolution for removal of his own removal is pending. Mark the word pending. The next sentence should be, oh, but yesterday it was rejected. Your lordship should know that. The word pending is used, own removal is used. This is suppression of the worst kind. Now, it's not just, I remember, I'll give you a citation. There is 1976 judgment of the lordships, which cites 64, just a digression for a minute. Lordship will see what standards the lordship is to maintain. And it's all right, your lordship is crowded today, so your lordship always can't maintain it. 76 Supreme Court cites 64. In 64, Mr. Settlewatt appeared. I'll give those two citations to your lordships. And it was found that one of the grounds in the SLP was false or wrong, misstatement. So Mr. Settlewatt appeared second time, and the judges agreed with him and he said, I never argued this ground. It is a misstatement. I never argued the ground. And he says, we will take your statement, Mr. Settlewatt, as correct. We did not grant leave on the basis of this because you never argued this ground. But we will revoke leave because there is a misstatement. Now, this misstatement is the basis of getting whatever order you got on 27th.
On 27th, according to them, there was no injunction.
No, but it's kindly. Now, kindly see, on 25th or 26th or 27th, would the speaker have disqualified or upheld and said no disqualification? Just can you go step by? This is very important. This is the biggest fiction being propounded to your lordships. Suppose there was no order by the vacation bench of this court. Just for a minute, efface the slate clean. The speaker would be at liberty on that day, which is the 27th, to either disqualify XYZ or not disqualify. The speaker had given them time till 25th, so his hands are free till 27, 2 days. Your lordship does it frequently, as I appeared for 2 hours, matter went until 9 o'clock in the night. The learned judge said that the effect is the same, we extend the time. And we'll be hearing the matter. When your lordship extends the time to file a reply, can the speaker decide? Stays or interim intervention by a lordship has many forms and models. They come in myriad colors. It's completely a stay. I am repeating, I was there for 3 hours and 2 days. Only Nabam was argued. Only Nabam was read. Now you can today say anything, and possibly there are video recordings of the hearing. It was argued in the evening till 9 o'clock. The learned judge sat from 5 o'clock. We can disagree on Nabam, but we should not say that Nabam is not the basis of your case. This is highly troubling. This is wrong. This is not the tradition of this court. Now, your lordship has extended the stay for filing, the time of filing reply, the only effect of which is the learned speaker's hands are tied. He can't do anything. And then the judge says, the learned order says, in the interim, and then he says, I am hearing it on Monday. So, your lordship is having, whatever your lordship makes of this cocktail, of suppression, of misstatement and of nabam. Just because this is Supreme Court. Just because it suits you, you can't say today that it did not have any role, you reject it. Over. Finished. That's not your case. And I hate to say what the bench would have said or held had this been told to the bench. That's not for me to speculate and possibly not for lordships to speculate. 193. Now see the prayer. Nabam was not the basis of our case. Nabam was hardly argued or touched upon. Nabam was one out of many. You moment, your lordship knows, direct or indirect by any means, your lordship disables the speaker from passing an order X or Y on disqualification. That is a temporary stay. And nobody will question the Supreme Court. Nobody will go ahead after your lordship says, I extend the stay. The court says, no, there was no formal stay. Therefore, I will go and decide the disqualification. Without time. That cannot happen. Your lordship knows that. So that is my first point. On reference, it is of direct relevance. The Honorable Chief Justice put that question squarely, that please do only tell us about reference. Absent an agreement with all facets of nabam, your lordship would and must with great respect refer it. Distinguishing it, your lordship has heard enough arguments, is not the correct course of action, is not going to really, it might generate more future litigation than solve any problem. Your lordship would either, in a binary sense, agree or refer. And agreement, according to our side, is not possible for the variety of reasons given respectfully to your lordships. Now, the second aspect is, your lordship has been taken a lot into this 7-day, 14-day notice of intention, actual removal. That's a valid point. But it should not be thought that the reference, as and when it is decided, if made by your lordships, is on a singular point of working out these days or the stage. The reference would raise significant issues, and one of the...
Have you formulated the issues with Dr. Singhvi?
Well, it's not in this writing form. I'll give a one page.
You can try it right now because
yes.
Now.
There are many issues, but the core issue would be... No, I'm just saying, in the light of the argument that 7 days or 14 days can be harmonized. Your lordships can hold on notice of intention to remove or the sitting. No, Manas. Your lordship would have to decide the larger core issue,
correct.
Which a 7-judge bench deserves to decide.
It's not just
whether your lordships can directly or indirectly conflate Chapter 3 and 10 schedule. Or to be more precise, 179 to 182, etc. and the 10 schedule. What is the chapter? We are not saying this is the only issue. I don't misunderstand me. I am on the nabam area point. There are many other issues. Tomorrow it will be said that I am giving up all other issues. No. On nabam area, the issue is not about days and time and sitting. Now, why it has already been said, so I will not repeat this, but just note with bullets why this conflation is very dangerous, or at least has to be decided. The heart of the error of nabam is a conflation, a mix-up of two distinct. One, I'm giving you in bullets the reason. One, not only Quixote, but starting from Quixote, case after case after case, constitution bench after constitution bench said, 10th schedule is a code in itself. This has been forgotten. CODE is repeated everywhere. Code in itself. Self-contained autonomous code. This word is very important, Manas. So, it's an impregnable, self-contained code. I made the point indirectly about notwithstand and subject to. But it's a code. That's Quixote starts with Quixote, it says it's a self-contained code. So, there can't be a conflation like this. 2. There is a continuity envisaged in 10th schedule, even if a lot of adventurous action is happening in the rest of the constitution. With the speaker. The para 6.1 which Mr. Sibal read, the proviso, illustrates two things. There cannot be a hiatus, stoppage or lack of continuity in 10th schedule. They have gone that far to anticipate that he is the speaker. This speaker, will have a disqualification against himself because he has done some untoward act. And your lordship has used another phrase, persona designata. Normally, in the 10th schedule, the persona designata is the speaker, and a persona designata means no one else by exclusion. That's the meaning of a persona designata. They anticipated and said, yes, it is a persona designata. But what in the strange case where I myself am facing a disqualification? No stoppage, no lack of continuity, no hiatus. Anybody else will be elected and will become the speaker, so-called, for the 10th schedule purposes. That's proviso to para 6 bracket 1 of the 10th schedule. The third reason you can't conflate, because the whole idea is continuity. The third reason is that, it was said, Mr. Sibal did say, but I want to elaborate on that there is no 10th schedule of the old kind, now only defences. Now, your lordship may not have looked this time, but earlier lordship saw. 4, 5 and 6 are very interesting clauses. The defences are very limited now. 4, 5 and 6 are the only defences. As my lord knows, there was 3, which is conspicuous by its absence by the 91st Constitutional Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defence, fellows. 1, merger. I'll not read it. That's clause 4. Now merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your lordship finding merger. It is not their case. Second exemption is, a kind of a sympathy condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is fine. Now, that brings me to the 4th bullet under this. What is the purpose of this? Your lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10th schedule. Where he said all this constitutional sin, stigma, purity, all that is there in that speech. That had happened, there were 2 actual names of actual MLAs in Haryana in 67. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Whereas your lordship is, with respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving, except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or he'll be removed, as Sibal said. So it doesn't really arise. It will not, should not come into your lordship's analysis of how to deal with this Nabab issue. The object is that as long as even the majority or large number or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defences were being used. So therefore it's a per se doctrine. In a per se doctrine is the 5th bullet. The speaker has to get only 2 things, fellows. Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. They're the only 2 categories. Now, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, your lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the speaker must act if the 10th schedule is a constitutional sin prevention. Your lordship cannot allow the other side to ask him, you can act, but you may be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your lordship asked, but on the particular point which both Chief Justice and Justice Narasimha asked, on the notice period. Your lordship said they may have some relevance to what is the notice period which the speaker gives. Now there, just for the record, your lordship asked that question. Just note down this and then I'll give your lordship. There are 3 judgments which are very important. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Shrimant Patil, also have 7 days. So Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So less than the rule prescribed. This has great relevance to both the Honorable Chief Justice's query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given and Shrimant Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Shrimant Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules. Okay. The legislative rule will not be mandatory and will not be dispositive. What matters is that because of the urgency and the constitutional sin involved, did he get an effective chance or not? If he gets an effective chance in 3 days or 2 days, it is enough. It's reasonable opportunity. This also sets a record statement because it is not as if Yedurappa is ruling. It has been distinguished and in fact, in that sense, not followed by a 3-judge bench. This is all based on alacrity. 2 days, 3 days, urgency. Of course, even 10 days may not be effective. Okay. I'm traveling in Iceland and I get 8 days notice. I may not be able to. And I'm right there, I know everything is happening, then 2 days is enough also. I'm not saying your lordship is dealing with this context, but your lordship schematically and conceptually separates the 2 categories. One is the floor of the house, the other is the 10th schedule. And just to end in a minute, that word sitting goes along with the word while. While was mentioned by him, sitting I had mentioned in my opening. 181 uses the crucial word sitting. Now, whereas in Parliament or in assemblies, sitting is on that day, that moment. It's not session. It's not intercession. That's a separate word used. Or whereas days when there are no sittings, which are intercession days. Sitting means an actual sitting of the House. So notified. When the attendance registers are open for the members to get their daily allowance of 1500 rupees. Therefore, Maharaj, that sitting word with while read together makes it crystal clear that the speaker is activated or disabled for that sitting when that removal will have relevance. While that removal in that sitting.